Pursuant to the statute, I must articulate on the record the Miller factors, and I believe that starts with the facts of the case. And in part, this incident unfortunately occurred on March 15th of 2000, where the victim, Willie Jones, who was 66 years old, the poor man had just retired. He was not a very large man. He was 5'7", 150 pounds. There were 4 defendants in this matter: the defendant, as well as a Mark Klopp, a Joshua Rogers, and a James Rivero. This incident occurred at a bowling alley where unfortunately, these 4 defendants decided to rob and beat the defendant. The beating was terrible. There was absolutely no question about that. He had a fractured vertebra at C4. He had been hit with fists. He had 6 to 9 ribs broken. His brain was swollen. He had a number of stab wounds that were ultimately determined to be from scissor wounds. The defendant actually took about 33 $1 bills off of the defendant. Ultimately, or not off the defendant, off the victim. Mr. Jones was put in the trunk of his car, driven around, and ultimately taken up near Morley, Michigan, which is north of Grand Rapids, to an area where the defendant had camped at some time with his family. Evidently, Mr. Jones had not died, but was ultimately killed with scissors after being stabbed numerous times. I will state that the record reflects that Detective Anderson, who was involved in this matter, said that the defendant was helpful and cooperative. There was a traffic stop later on in this matter. Ultimately, the defendant was interviewed. He cooperated with the police. He took the police to Morley, where Mr. Jones was found. He also helped locate, evidently, one of the other co-defendants. I do not believe that the defendant in this matter was a leader in any way. I found that his testimony was probably correct, that he did not know 2 of these individuals very well and was friends with one of them. During the trial of this matter, evidently during the course of the trial, one of the defendants, with the consent of the family, was offered to plead to second-degree murder. He was ultimately sentenced to 35 to 60 years on second-degree murder. During jury deliberations, it's my understanding that with consent of the family, again, I assume, the defendant was offered to plead to second-degree murder. His attorney and his mother both counseled him. Evidently, his mother was counseling him not to take the plea deal for whatever reason. The defendant, I don't think, fully appreciated the legal consequences of his actions, although I do believe from his testimony that he does understand it now. They rejected that offer. Ultimately, he was found guilty and was sentenced to life in a prison with no possibility of parole. A number of factors need to be looked at with regard to Miller. The defendant's age at the time was that he was 17 and a half years old. The defendant's immaturity. The defense attorney this morning, the representative, said that he was not unintelligent. However, this court's familiar with the juvenile court worker that testified this morning, finds him to be a very credible witness, and he was working with the defendant, trying to help the defendant out as a somewhat father figure, and he said that the defendant was immature at the time, very immature, and I have no reason to doubt that testimony. Next, look at the defendant's impulsiveness, and I think this has to do, I look at this as to deal with substance abuse issues and histories. There is repeat evidence in the record in the exhibits that we heard today, as well as that I read, that this defendant was involved in marijuana, sniffing gas, huffing, alcohol abuse, cocaine, acid, ecstasy, mushrooms, and some of this occurred and I believe was somewhat encouraged by the mother in the house. The defense attorney said this morning that the defendant was able to appreciate the risk, although quite frankly I'm not convinced of that after reviewing the record and listening to all the testimony. I don't believe that the defendant could totally appreciate the consequences of the situation he was in, especially when he had basically given a conviction or given a confession and goes to trial and jury was in deliberations. Another element under Miller is the family's environment. That was obviously a terrible environment. Now, any of these factors don't justify somebody killing somebody. But the defendant's family environment was not good. His father, evidently, according to records, was an alcoholic, died when he was about 5. I'm not sure that he ever got along with his stepfather. His mother was, it sounds like, an alcoholic and involved in drugs. He was subject to sex abuse. He was kicked out of his home shortly before this incident occurred. The defendant was defiant, defied authority. Another Miller factor is whether the defendant had the ability to extricate himself from his family or home environment. I don't believe he had the ability. This was occurring for a long period of time. He was certainly part of the problem, but I don't think he had any alternatives other than the juvenile court system that he went through. Another issue is the extent of the defendant's participation in the homicide. He was clearly involved in this. He gave a confession. I don't think he was the leader. I don't think he probably was the most aggressive, but he clearly was involved. Another issue